So I'd like to thank you for attending our webinar today. It looks like we've got a good turnout. Today's presentation is going to talk about some of the mistakes people make when preparing their wills and powers of attorney. I hope you enjoyed the presentation. I'm going to turn it over to Jacqueline now to introduce our speaker.
Alrighty, thanks everyone again for joining. Good morning. The team and I are very happy to be hosting our first webinar together and the first in a series of upcoming webinars. So before we begin, I did just want to point out a few things about the virtual webinar today and some of the technology in case anyone's not familiar with the Zoom webinar. So this session is being recorded, and again, for privacy, everyone other than the team here, their microphones and videos have been turned off. There is a chat feature available, and this can be accessed at either the top or bottom of your screen. Sometimes you just have to hover over for a minute. If you have any questions, you can post them there, and we will try to address those at the end of the session. So the actual formal presentation today will be about 45 minutes, and this will leave about 10 minutes at the end for any Q&A. Of course, if we don't get a chance to answer your question, we can reach out to you afterwards, or you can always contact us as well. Again, depending on the type of device you're using, you might see our videos on the right-hand side of your screen. If you want to hide some of those, by hovering above the top video, there will be 3 bars, and you can toggle with that to hide some of the videos and just see the PowerPoint presentation. So we chose the topic of estate planning today as it's obviously a very timely topic. COVID-19 has had a lot of people thinking about the health and the health of their loved ones. And at the end of the day, we really just want to make sure that our loved ones are well taken care of in the event that anything happens to us. So while Steve, Rami, and myself do work with clients a lot on estate planning, for today's presentation, we wanted to bring in an estate planning lawyer. So our speaker today is Keith Masterman, and Keith is an estate planning lawyer and vice president with CI Global Asset Management's tax, retirement, and estate planning team. Keith has extensive knowledge of estate planning that has been gained through his education, his experience working in private practice at a Canadian bank, and now with CI in their estate planning department. So with that, I will pass it along to Keith to take control of the presentation and present to us the 7 deadly sins for today.
Great. Thanks very much, Jacqueline. And thanks, Stephen and Rami as well. As Jacqueline said, I'm a lawyer, and all I have done over the last, say, 35, 36 years of my career is estate litigation, estate administration, and estate planning for high net worth Canadians. And what this presentation today is really 7 things that I've seen that people have done incorrectly in their estate plan, and 7 things that you might want to watch. In fact, this presentation was originally called 7 things that I've seen that have gone wrong over the last 35 years of my career. But my wife worked for the newspaper in the town where we raised our kids, and she looked at it and she said, "That's a terrible headline. No one's going to come to your presentation." So she made up my title today. So if you like it, it's because of my wife, and if you don't, well, chances of you meeting her are pretty slim, so I think that's okay too, that I've told you that story. But what I hope you do today is I hope you find 2 or 3 things that the next time you review your will, or the next time, or write your will, you find a couple of things in here you think, you know what, I should remember that, and I should talk to my advisor about that, and really get some information about that. So without further ado, let's see if I can, there, whoops. Wow. The 7 sins that we're going to talk about today are, the first one is no estate plan or an outdated plan. And the statistic I always like to start with, and we'll get into this in a minute, is that 56% of Canadians don't have a will. But more alarming than that is that 30% of Canadians who have a will wrote that will when their oldest child was born. And that was me until I read that statistic. So I'm going to use myself as a bad example in this presentation. My wife and I, Chris, wrote our will, and we tucked it in a cupboard, and it sat there. We're grandparents 3 times over. We've got 3 grandsons. And so until I read that statistic, my will was old and really didn't reflect my family and the reality of my life. And we'll go through that in a minute. Second thing we're going to talk about is incorrectly named beneficiaries. I went to a presentation by Madam Justice Dietrich about half a year ago, and she said this is still the #1 issue that the courts find that people have done incorrectly, naming beneficiaries incorrectly. And you know, words change constantly. The people who would have been my children if I had died 5 years ago are completely different than who my children are today. And so I have to look at my will and say, does this really reflect the new state of the law? The third one is inappropriate choice of executor. And when we talk about that, I'm not going to tell you all the things an executor does. You guys already know that. You've been to a lot of presentations where someone like me told you all the duties of an executor. What I want to do is I want to talk to you about the conversation I had with my executor when I made him my executor. Spoiler alert, my executor is someone I love. It's my son, Jack, my oldest child. And so I sat down with him and talked about the liability he's taking on and the responsibility he's taking on. And that's the conversation I want to have with you. I then want to talk to you about ignoring assets with sentimental value. You know, for the last 35 years of my career, my mantra has always been that I only have one job, and that's to make sure your family can still have dinner together after you pass away. And where I see families blow up the most is sentimental value assets, grandma's china, grandpa's gold watch, all of those sort of things. But this is also a really good chance to talk about digital assets. The Law Society of Ontario, where I spend a lot of my time, has said certain things about digital assets, and so have the courts, and it's important that you think about those things when you write your will. The next thing we're going to talk about is lack of care of registered product designations. And Steve and Remy will tell you that registered products are wonderful, wonderful things, and they are. And we're going to talk a little bit about why they're wonderful things, but we're also going to talk about a couple of cases, or maybe just one case, and that's the Kalmuski case, which was heard in June of this year. And the reason we're going to talk about that case is it changed the law of how you make a beneficiary designation. And you know, when Steve and Remy and Jacqueline are talking to you about your beneficiary designations and your registered products and your insurance products, they're probably talking to you a little differently since June. And that's because the onus has changed in that case. We're then going to talk about inappropriate use of probate minimization tools. I want my executor to get probate. Probate is a wonderful, wonderful thing. And I'll talk about why when we get there. But that doesn't mean I want him to get probate on the entire value of my estate, because that's a lot of money, and we'll talk about why in a minute. So I want to reduce it, but I don't want to eliminate it. And we'll talk about why. And then we'll talk about failure to consider the words and powers set out in your will. Every word of your will is there for a reason. Your lawyer doesn't get paid by the word. Everyone's interested in the first 2 pages of their will. That's the page that says everything to my spouse or my children or my nieces or nephews, but then they ignore the last 8 pages. And those pages are so important because they limit what your estate can do. So with that, we'll see how far we get before I'm given the hook by Steve, Remy, and Jacqueline. And we'll see how I can, just see. No, wait a second. Okay, so let's talk about the first thing, which is no estate plan or an outdated plan. So as I said to you a minute ago, 56%, sorry, I'm having a little trouble flipping these pages. There we go. The statistic there is a little outdated. The statistic I like to use, and what I used a minute ago, was 56% of Canadians do not have a will. But of those Canadians with a will, 30% wrote that will when their oldest child was born. And as I said to you a minute ago, having an outdated will is as dangerous as not having a will at all. And I was that guy who had an outdated will. And I'll use myself as a bad example. Here's some things that have changed over the last 35 years of my life. First of all, my son is now married. And so I know in my heart of hearts that my daughter-in-law is going to wake up one day and realize she could do better than my family. I joke a little bit, but I'm also old enough to have lived through the year when the divorce rate went up by 200% in 1 year. And then the following year when it went up by 200% again during the liberalization of the divorce laws. I also know that today the divorce rate is 48%. So I now have a beneficiary, my son, and I have a woman who means a lot to me. My daughter-in-law is a wonderful, wonderful person, but my will doesn't talk about what I want should Jack and Kelsey divorce. And it might be that I want Kelsey to still inherit. She's very important to me. She's the mother of my 3 grandchildren. But my will doesn't set out what I want. And so that's a problem. I also have 3 grandchildren now. And you know, my will obviously said everything to my spouse and then to my children. And if one of my children dies, it goes to their children. But I didn't know the kids then. I do know them now. And so I look at my children and my grandchildren, I think, do I want to leave them something as a memento? Do I want to help with their education? How do I want to handle those people that I now know? And that's completely silent in my will. Another thing that's silent in my will is that I can now use my will to hand down my values. If you read about estate planning and read about what I do for a living, you read an awful lot about handing down money and handing down values, because your will should do both of those things. And handing down your money in a tax-efficient way is in many ways really, really easy, because all I really have to do is go to a specialist and say, I want my son to inherit or my daughter to inherit. and they'll help me with the tax efficiencies. We'll get into some of those though. But handing down your values is also something you want in your will. I'm a trailing baby boomer, and I see my next generation, my son and daughter, with totally different values than I have. And I want to use my will to say, I want to leave some money to my community, because I want to say to my kids, you're important, but so are these causes. So is giving back to my community, so is being involved. But you know what? My will that's 35 years old didn't have any of that stuff in it. Why? Because Chris and I were living pretty hand to mouth back then. You know, I got paid one week and we spent the money on crazy things like the mortgage. And then she got paid the next week and we spent money on crazy things like heat and hydro. But now we have a little more wealth and can do a bit more of that. And of course, the biggest change in my life, and I sort of alluded to it already, is I have 2 children. And clearly my will said, once Chris and I die, to divide through by however many children I have. But I didn't expect when I wrote my will that one of my children might be disabled. But my daughter has 2 slight disabilities. And so my will has to look at a whole bunch of special planning to preserve her benefits. There's 2 types of trusts in Canada that are wonderful for people like with disabled beneficiaries. One's called a Henson Trust. And if properly worded, that will protect your beneficiaries' provincial disability benefits. And there's also a qualified disability trust. And that's a great trust because it has graduated tax rates. You see, every other type of trust, or most other types of trust in my will, every nickel that's taxed in that trust is going to be taxed at the highest marginal tax rate. And remember, that's 53.53% in Ontario right now. But a qualified disability trust doesn't have that. But you know what? To have a qualified disability trust, if you have a disabled beneficiary, and I have a whole presentation on disabled beneficiaries, means that your disabled beneficiary has to qualify for the federal disability tax credit. And my beneficiary doesn't qualify. I'm one of the approximately 300,000 Canadians who doesn't. So my planning has to be more sophisticated. The bottom line is my will might as well have been something I ripped up and threw away, because it didn't reflect my values, it didn't reflect what I wanted to say to my kids, and it didn't reflect my family. Before we go on, and I promise I'll do a little faster in the next one, Steve, because he's probably worried about 45 minutes, Keith. I do want to talk a little bit about intestacy law. So if you die without a will, you die intestate. And there's a provincial scheme that says where your assets go. So in my case, with 2 children and a spouse, the first $200,000 of my estate goes to my wife. And then the remainder, 1/3 goes to my wife and 2/3 go to my children. And that might be what you want. It's not what I want. Chris and I worked like dogs the last 35, 40 years to look after each other first and then the kids. That's just how we are. But it might be what you want. But you know what? It's still important to have a will, because it doesn't allow you to define how people are related to you. And I'm going to tell you a story before we go on. And the story is a case that was heard in the court about 1.5 years ago. It's called Repeaters. What happened to Repeaters was this. There was an elderly couple called Eileen and Lester Peters. And if you lived beside Lester and Eileen Peters, you'd say to yourself, what a lovely older couple with 5 adult children. You'd be wrong. What you really had was a lovely older couple, and Mr. Peters had 5 adult children. He had 4 daughters and a son, and Mrs. Peters had 1 child. Because you see, Lester Peters was married before he married Eileen, and he and his first wife had those 4 daughters. When his youngest daughter was a couple months old, his first wife died, and Lester was raising the girls on his own. He met Eileen, got married, and then a few years later, they had that 5th child, their boy. All the kids were grown-ups. Lester Peters died in 2008, and when Lester Peters died, he left 0 to his wife, nothing. He left everything to his 5 children. And I don't think it's that he woke up one day and said, boy, I hate Eileen, how am I going to tell her? I think what happened was that he had a whole bunch of assets in joint name and a whole bunch of registered assets that passed to Eileen outside his will. And I think he said to himself, Eileen's well looked after. All I want to do is tell the kids how important they are by what little goes through the estate leave to them. The problem is, about 3 years before Mr. Peters died, the company he operated, he was a small business owner, the company he operated went bankrupt. And all those assets in joint name were securing debts of the corporation, so they were all gone. Lester and Eileen started living very liberally off their registered products because it's more or less all they had. Bottom line is there was nothing for Eileen in the will, and she wasn't able to live. So the 5 kids got together, because they were good kids, and they said, what are we going to do for mom? It's humiliating for her to have to borrow money every time she wants to pay for heat or hydro or groceries. So what are we going to do? So they decided that everything they inherited from their dad, they were going to give back up to their mom, just give it to their mother. That's really bad estate planning. because the night before you die, everything you own is deemed to be sold at fair market value. And all of the assets with a capital gain, that capital gain has to be brought into income the year you die. And any registered products like your RSP or your RIF, 100 cents on the dollar is added to income in the year you die. The bottom line is, in the year of your death, you're going to have a massive income inclusion. And remember, for tax purposes, and remember, the highest marginal tax rate after 210,000 is 53.53%. You're going to hit that number and then some in the year you die because of that deemed disposition. But if you leave money to your spouse, there's a rollover. And that deemed disposition only happens when your spouse actually sells the assets or when she dies or he dies. And so if Lester had left money directly to Eileen, there would have been less money for CRA and more money for the kids. But that's not what they did. And so it went through the kids to Eileen. But she lived off that money until she died. After she died intestate. The whole purpose of this section of the conversation, she died without a will. So the 5 kids got together again. And one of the daughters said, "What's left in mom's estate?" Remember, this had been their money. They gave it to their mother. "I guess we divide by 5. And the brother said, "I guess we divide by 1. You're stepchildren. You're not children." And there's not a piece of legislation in this country that recognizes the law of recognizes stepchildren as having any rights. They all went to court, and the son won. The judge said, "This is immoral. This is disgusting. This is horrid. But this is the law. And I'm not going to write you a will after you die because you didn't want to write one before you died." So I guess my first sin is, you got to have a will, and it should be up to date. Don't be like Mrs. Peters. If Mrs. Peters was here today and she was chatting with you and you said, "How many kids do you have?" she'd hold up 5 fingers. She raised those girls. They called her mom. They called her mom. But unfortunately, that's not what the law says. So my first thing is really just make sure you have a will and make sure it's up to date. Let's see if we can move on. I don't know why it does that, but anyway, we'll get through this. So my second sin is make sure you name your beneficiaries. That's not the right one. There we go. Are you controlling now or? Okay. Make sure you name your beneficiaries correctly because names make a difference. And a few minutes ago, I talked about the word children and making sure that the word children is defined the way you want it to be defined. And I told you that if I died 5 years ago, the people who were my children would be completely different than who my children are today. And that's because of the passage of the All Families Are Equal Act. The All Families Are Equal Act redefined parent and it redefined child in the province of Ontario. So, you know, I mentioned my 3 grandchildren. When the first 2 were born, and certainly when Jack and Hannah were born, my children, the birth certificate said father, mother. Today, when the 3rd grandchild was born last year, it said parent 1, parent 2, parent 3, parent 4, because Ontario now recognizes 4 parents for a child. And child changed too. So if I had died 5 years ago, my children are anyone I fathered during my life or adopted during my life. Whether I knew about them or not, I fathered them during my life. And anyone I fathered within 9 months after my death, the involuntary sommaire period. But today, children means anyone I fathered during my life, whether I knew about them or not, anyone I adopted during my life, and anyone I fathered within 3 years after my death. So they've extended that period for me to father children after I die. So what does that mean for my estate? Well, it means that my spouse or my girlfriend can come to my executor after I die within 6 months and say, "I really miss Keith. I might," she don't even have to say she will for sure, "I might choose to have another child with DNA material he left behind." And if she makes that election and my estate goes to my children because I die intestate or I hadn't defined the word child in my will, my estate is now frozen for 3 years because we don't know the class of beneficiaries. And 3 years is a long time for people to wait for their money. So make sure children is defined, in other words, are defined the way you want it to be defined, because all these words have legal definitions, and you got to be careful of those definitions. Now, let's face it, Chris and I are not going to have any more children, you know, not a chance. But that doesn't mean that the word child is not important in my will, because think about my will. If something happens to Chris and I, the money goes to my children. But if something's already happened to one of the children, let's assume, God forbid, Jack is dead, it goes to his children. And if something happens to one of my grandchildren and money's held in trust until they're 18 or 25 or whatever age I choose, it will then go to their children. So the word child is important because my will could go on for 75, 80 years, depending on how people die in what order. So it's really important I worry about these things. I think I'm going to skip a little bit. Nieces and nephews is important too. I'll just mention that because the law only recognizes blood. So I have 10 nieces and nephews. My brother and my two sisters have 10 children between the three of them. But Chris's brother also has two children, two daughters, Lindsay and Megan. They're just as much my nieces as my blood relations are. They came around after I got married to Chris. I took them tobogganing, all those things that uncles are supposed to do. If I left my estate to my nieces and nephews, it would only go to my blood relations because the law only recognizes blood. And now we're playing a bit of Russian roulette, aren't we? Because now we're worried about which of Chris and I die last. Because all my estate will go to Chris and all her estate will go to me. But then if we say, upon the death of the survivor, it goes to our nieces and nephews, if I outlive Chris, my 10 nieces and nephews get everything. But if Chris outlives me, her two nieces get 100% of the estate. So again, I have to look at that and say, how am I defining these words in my will? I'm going to skip down and talk about charities for a minute. I mentioned to you in my introduction that one of the things I want to do in my estate is I want to pass down my values. And I use charitable gifts to do that. So a charitable gift in a will is a wonderful, wonderful thing if you want to, if you have a cause that means a lot to you, or if you, like myself, want to hand down your values. So in my will, I have two charitable gifts. I have one to the Stratford Shakespeare Festival Theatre and one to the Perth Huron United Way. Because you see, I live in Stratford, Ontario. That's where I am today. And those two causes mean a lot to me. I'm a director of the United Way. But what happens if I name that charity incorrectly? That's what we're talking about here. So rather than saying the Stratford Shakespeare Festival Theatre, I leave it to Stratford's Festival. Or let's say I leave it to the Stratford Shakespeare Festival Theatre, but 2 years after I've written my will, but before I die, it changes its name. It merges with the Shaw Festival and becomes the Festivals of Southern Ontario. What happens to that gift? And that's what I want to talk to you about for a minute. So before we do that, let's just talk about charitable gifts for a bit. A charitable gift, I would never suggest you put one in your will unless you have a cause that means a lot to you or you're trying to hand down your values. But if you do, it's got a wonderful, wonderful tax advantage for you. Because you see, a gift in a will, a charitable gift in a will can be used, up to 100% of that gift can be used to write off income in the year of your death, the year before your death, or for the next 5 years. And remember, in the year of your death, because of that deemed disposition, there's going to be a huge income inclusion for tax purposes. So a charitable gift can be used to write off some of that and have less money for CRA. It's kind of the gift that keeps giving. If while you're alive, I think the limit is 75% write-off, but it's 100% in the year of death. Also, you'll notice at the bottom of my page, capital gains realized on public securities are nil. So let's say I have a whole bunch of shares of TD Bank and they've done really, really well. My son, as the executor, can take those shares, transfer them to the charity to satisfy the charitable gift, and that's not even included in that big deemed disposition of taxes. So it produces income on this side, and it is a write-off against income on this side. So it's a wonderful thing. But that's not what I'm here to tell you about. I wanted to talk to you about the Cypre doctrine. The Cypre doctrine says a gift to a charity will fail should the charity be improperly named. So I've said Stratford's Festival, or the name ceases to exist. It merges with the Shaw Festival and changes its name, unless I have a separate power in my will saying to my executor, you can try and select a charity that looks like the charity I mentioned in my will. If I don't have that, then my gift fails. And these come up all the time, but the case I wanted to talk to you about was called BC versus Ridge Meadows. It's one of my favorite cases for this particular thing, but these come up all the time. And what happened in the Ridge Meadows case was that an elderly gentleman left his entire estate, which was $2.9 million, to the Society for Retarded Children, Haney Division. He lived in a little town called Haney. It doesn't take very long to realize there was nothing called the Society for Retarded Children. That's just not the way we talk in Canada. But after he died, 3 charities came forward and said, I think we're the charity. One helped people with mental disabilities, one helped children, and one did good work in the Haney area. The executor's going, well, I can only choose one of you. The Cypre doctrine doesn't say you can just divide up by however many you want. I can only choose one of you. I can't figure out which one of you is the charity that my uncle meant. And so they all went to court. But you know what? The charities and the executor are not the only people who went to court that day. The deceased second cousins also showed up. Most of them he'd never even met. But they said, listen, if the gift fails, because the Cypre doctrine says the gift fails if it's named incorrectly, if the gift fails, he dies intestate, and we're his next of kin. We get all his money. And so the judge looked at it and said, well, there is no clause. There is no separate clause authorizing the executor to choose another charity. So I guess the gift fails, and the second cousins get everything. Think about how many ways that was wrong. Because of poor drafting, a lot of money was spent on a court application. A ton of money went to CRA because all those charitable benefits we just talked about don't exist. And a whole bunch of people who he didn't even know became his beneficiaries because he died intestate. And so I'm going to go on to the next sin, and that is inappropriate choice of an executor. And as I said to you, I'm not going to tell you about all the wonderful things an executor does. You probably know about them all. And if you don't, Steve and Remy and Jacqueline can tell you about them. We have a checklist on our webpage, and I think there's something like 78 different duties of an executor. The executor is the person who steps into your shoes. It's the person you name in your will with the legal obligation to administer your estate, wind up all your debts and all that sort of thing, pay off all your debts, and then transfer your assets to the next generation. What I want to talk about is the conversation I had with my executor when I named my executor. So first of all, an executor is actually 4 different people. An executor is a bit of an accountant, because my executor is going to have to deal with the accountants and CRA and the tax returns and all those things in my estate. But he's also going to have to keep the records of my estate in what's called a triple ledger form, which I think is a really outdated and weird system, but it's important, and we'll talk about why in a minute. So he's going to have to be a bit of an accountant. He's also going to have to be a bit of a lawyer, because he's going to have to make decisions that can have legal repercussions all over the place. And he can't go to the lawyer all the time that's hired for the estate and make these decisions. And if he makes the wrong decision, he can be personally liable. And that's a big problem. And I'll give you an example. There was a case from last year called Markov and Texera. What happened in Markov and Texera was this. There was an elderly woman named Maria Markov. And Maria Markov had the best neighbor in the world. He was great. His name was Anton Texera. He would come over and he'd take her to medical appointments. He helped her with her grocery shopping. He mowed her lawn for her. He plowed the snow for her. He was a wonderful guy. Maria found out she was dying. And so she went to her lawyer and she said, I want to do 2 things. I want to go home today and I want to give Anton a check for $150,000 to thank him. He's a good neighbor. I've started mowing my neighbor's lawn because you never know, right? And secondly, I want to rewrite my will to leave him another $150,000 once I die. So he's going to get $300,000. So the lawyer redrafted the will and Maria went home. Next time she saw Anton, she said, Anton, here's a check for $150,000. He didn't do what a lot of you would do, which is to say, no, 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 you keep your money. He went, thanks, and jammed the check into his pocket, ran down to the bank. When he got to the bank teller said, there's not enough money in Maria's account. This is going to be NSF. But don't worry about it. Maria comes in every Thursday morning and she rearranges money in her account. She has tons of accounts. She just gets confused about which one she writes her checks on. I know, the bank teller's breaching privacy, I know. But at any rate, if you come back Thursday, there'll be lots of money in the account. So Anton takes his check and goes home. But you know what? Maria did not go to the bank on Thursday. She died instead. So Anton has a check for $150,000. He goes to the executor and says, here's a debt of the estate. Pay me the $150,000. I would have paid it because in all the years I've done estate administration, we're told that outstanding checks are debts of the corporation, debts of the deceased, and you pay off the debts of the estate. Maria's executor said, not a chance, I'm not going to give it to you. You can sue me if you want. And he did, and he lost. And the court said, normally you would pay these amounts, but this is a gift. And for a gift to be valid, there has to be an intention to give. Well, here's a check for $150,000, an intention to receive, yoink, thanks, I took the check, and delivery. And the court said, a check's not delivery. It's just a promise that sometime in the future, you will make a delivery of the funds. So therefore, the check's void. I would have paid the money, and I would have been liable for $150,000 personally as the executor. So he's going to have to be a bit of a lawyer, and that can be a problem. He's also going to have to be a bit of a general contractor. One of the first duties my son's going to have is to go in through this house and clear out all the stuff we have. And you know what? We got a ton of stuff. We've got, Jack and Hannah would go to school when they were in grade 3 and they draw a picture of a line. It's somewhere up in our attic because that's our sentimental value stuff and we just don't get rid of it. We're going to tell Jack at a time when he's grieving our loss, he can come in and he can get rid of all his childhood, but that's one of his jobs. One of the saddest estates I've ever worked on was a man and a woman and their 3 children. The children were 11, 9, and 6. He was a private pilot and he took his family from the town where I lived at the time to Prince Edward Island for a vacation. The plane got as far as northern Quebec. When it went down in a terrible storm, he, his wife, and his 3 children were all killed. His executrix was his 86-year-old widowed mother. She just lost her only son, her only daughter-in-law, and her only 3 grandchildren. And one of her first jobs was to go in and clear out all of their personal stuff. It's a horrendous job for an executor. And the last thing Jack's going to have to be is he's going to have to be a bit of a psychologist, because he's going to have to put the family together again when they're grieving, when they're sad about my death. I hope they're sad, knock wood, someone will be. He's going to have to put the family together. And that could be very difficult. First, because we're all grieving in different ways. And secondly, because there's a trust in my will, and he's the trustee. So I'm changing a relationship from being brother and sister to being trustee and trust, from being babysitter and babysat. So the first thing I talked to him about was that. The next few slides don't really, you can read them and enjoy them all you want, but the other thing I wanted to talk about with my executor was the liability of my executor. And I really want to talk to you about 3 different things. Let me check the time. So, okay, I've got some time. I want to talk about the liability of my executor. So my executor, remember I told you a minute ago, he's going to have to keep the records of the estate in that triple ledger form when I talked about him being an accountant. That's really important. Because you see, Jack's going to have to pay a lot of expenses of the estate. He's going to have to pay a real estate agent to come in and appraise my house. He's going to have to pay someone to appraise my coin collection, all of that sort of stuff. And I'll tell you what's going to happen. You're going to open a bank account called the Estate of Keith Masterman, and you're going to jam whatever money you can into it, and then Jack's going to start paying debts out of that. In law, Jack is paying his own debts. Those are debts not of the estate, but of the executor. So really what Jack should be doing is paying them himself and then going to that estate account and reimbursing himself. But no one does that because that'd be going 2 sides of a triangle. But at the end of the day, after my estate is wound up, any one of my beneficiaries can look at everything Jack did in that triple ledger form and say, I think you paid too much to the lawyer. I think you paid too much for that appraisal. I think you charged too much. And they can force Jack to go to court and prove his account. It's called a passing of accounts. And if at the passing of accounts, they say, yeah, Jack, we agree with Hannah. You paid too much for the lawyer. You paid too much for the appraisal. It doesn't mean the appraiser and the lawyer don't get paid. It means Jack doesn't get reimbursed and it comes out of his pocket personally. So I have to be worried about that and talk to him a little bit about, is that something he's willing to take on? The other thing I have to talk to him about is his residency. The law of Ontario says that if my executor is a resident of the Commonwealth of the United Kingdom, they can administer my estate without obtaining a bond. However, if my executor is not a resident of the Commonwealth, they have to go out and they have to get a bond equal to the value of my estate, which is going to cost him money, and then he's going to have to renew it every year, which is going to cost him money. Now, Jack and Kelsey live in London, Ontario, really close to here. In fact, that's one reason we live in Stratford. It's close enough that we get to see our grandchildren, but far enough away that we don't have to see our grandchildren. So it's a good compromise. But kids move. 25% of seniors in Canada do not live within 400 kilometers of their children anymore. Jack's generation moves more often than anyone. So let's say in 2 years he moves to New Zealand. I don't have a problem because New Zealand is part of the Commonwealth. But let's say he decides to go somewhere more exotic and they decide to go to Detroit. So they cross the bridge and go to Detroit. I've got a problem because now I have a non-resident and it can affect those bonding requirements. In fact, it could have a big effect for me because I've got that trust. And trust law says that the residency for a trust for tax purposes is where dominant management and control of the trust reside. And if Jack lives in Michigan chances are really good IRS is going to take the position that that trust is now an American trust. And it's going to be taxed there. And my financial advisor, who I want Jack to work with in Canada for the trust, will not be able to accept instructions from my son because he's a non-resident. So I have to worry about his residency. And I constantly have to look at my will and say, where's that guy a resident now? And the last thing I have to worry about is the estate information return. About 4 years ago, the government of Ontario decided they were not getting enough probate fees. And we'll talk about probate in a minute. And what they decided the issue was that people were underestimating the value of your assets in your probate application, because probate is based on the value of all your assets in your estate, and then there's a mathematical calculation. And they decided that people were not putting the right values on their assets. Because you see, when you do your probate application, all you have to do is use best efforts to value your assets. So Jack can go to the last notice of assessment of my house and say, Dad's house is worth $350,000, and put that down. Remember, I live in Stratford, so it's a lower value than your houses. And the government said, people are underestimating. We think Keith's house worth more than 350. And they also said, people aren't including all their assets. You're telling me no one died with a car, painting, art collection, coins, anything in the last like 200 years? So they changed the system. And they said within 180 days of obtaining probate, my executor, so your version of Jack, is going to have to go out and he's going to have to file with the Ministry of Finance an estate information return. And that estate information return is going to guarantee that every value of every asset is accurate and that all assets passing through my estate are listed. So suddenly estate administration got more complicated and more expensive, because Jack can no longer say, well, the last notice of assessment of Dad's house was set 350. He's going to have to go out and get a formal appraisal done because he has to guarantee the values. If he's wrong, the ministry can audit his account. They don't have to, they won't audit every account, but he could be audited. And if he's audited by the Ministry of Finance and they decide that he was incorrect in his estate information return, the penalty is $1,000 for my executor, plus twice the probate fees they feel I avoided, plus up to 2 years in jail for my executor and any professional, such as a financial advisor, who assisted in the valuation. Now, I don't for a minute believe my son's going to go to prison because he underestimated my house in the probate application, but the penalty's there. And when I chose to have a family member as an executor, I had to talk to him about that issue. So let's move on to the next sin, which is ignoring assets with sentimental value. As I said to you before, I believe that the number one place that families blow up is sentimental value assets. And I believe my only job is to make sure your family can still have dinner together after you pass away. And so I really worry about sentimental value assets. Grandma's china, grandpa's coin collection, because those are the assets people seize on as memories of you, and they're going to miss you a lot, and they're going to grieve very personally. Do you guys remember Robin Williams? He was a comedian. He died several years ago. His estate is a great example of this very thing. Robin Williams died leaving $100 million. He had 3 children from wife number 1 and wife number 2. I think it was 2 children from wife number 1 and 1 from wife number 2. Could have them reversed. And he had a 3rd wife. In his will, he left every nickel of that $100 million to his 3 children. He said to his 3rd wife in his will, you have 2 things. You have the right to live in our house for the rest of your life. You have to pay all the expenses, but you can stay there. And everything we accumulated from the moment I said I do forward is yours. So anything we accumulated from that day of our wedding forward is yours. Mrs. Williams found she couldn't afford the house. She went to her stepchildren and she said, listen, I'm not a very wealthy woman. You guys just inherited $100 million, I think, and I can't afford this house. So I'm hoping you'll start paying the expenses of the house. It's going to be yours anyway eventually, because after I sell it, after I leave it, you guys can sell it, keep the money. I'm hoping you can pay the capital expenses of the house, the taxes, repairs. And the kids said, not a chance. And they all went to mediation. They settled that issue reasonably quickly. What was it they continued to fight about for 9 more months? Mrs. Williams said, I would also like the tuxedo my husband wore to our wedding as a keepsake. And the kids said, not a chance. You're entitled to everything he accumulated after you got married and he wore that to the wedding. It's ours. People fight over sentimental value assets, and you've got to make sure that somehow you talk to your family about how you're going to divide those up. There's lots of different ways of doing so. The other thing I'd like to talk about before we move on, and I realize I have about 9 minutes with you. I would also like to talk about digital assets. Those are all those things that float around in cyberspace. And the reason I want to talk to you about them is because they are the sentimental value assets of tomorrow. Those are things like your Bitcoin accounts, your Facebook accounts, your Google accounts, whatever else you might have out there. I'm a bad person to talk about these in many ways because I think I only have the one, and that's my Loblaws card, and I can't find it. But I know I have it somewhere, and I just keep saying to my wife, "Yeah, I took it and got it scanned, but I have no idea where it is anymore." But it's important you deal with those assets in your will, and it's important for 3 reasons. One, they're valuable. The average Canadian has about, I think it's $8,000 or $9,000 in digital assets. And remember, I'm bringing the target down, so you probably have more. And it's bad estate planning to leave money on the table. Secondly, those are the digital assets of tomorrow. If something were ever to happen to Jack or Hannah, God forbid, I would want every word they put on the internet and every picture they put on the internet. If you come to my house, this house I'm in right now, and you go over to that closet that's just outside this door and open it, you'll see photo album after photo album after photo album. Then you'll see a big box of photos because we got tired of putting them in albums. If you go to Jack and Kelsey's house, you won't see that because everything's online. Everything's online because that's the next generation. And the third reason it's important is the incidences of identity theft are massive after you stop monitoring your online accounts. And you stop monitoring your own online accounts really quickly after you die. It's almost a direct correlation. So it's important you deal with them. But here's the problem, and I'm going to tell you about a couple cases. The first case I'm going to tell you about, well, I'm going to do 2 of them at once. I'm going to talk to you about the Stassen decision and the Daftari decision. And we'll start with Daftari. Ms. Daftari was a beautiful, beautiful, beautiful woman. She died when she was 23 years old. And the reason I mention how very pretty she was is because she had just won the Face of Asia contest. And it was believed she was going to become one of the world's top models. Her career was set. It's going just like that. Shortly before she died, she got married, or at least she thought she got married. It turned out her husband had a wife and a couple of kids, but she went through a form of marriage. Immediately after her marriage, her conversations with her girlfriends changed. She started talking about sexual abuse. She started talking about psychological abuse, and she started talking about physical abuse. She was terrified of her husband. She also believed in her heart of hearts that there was a stalker living in her apartment building, and she was terrified of that man. One night, she was in the apartment. She was packing because she decided to leave her husband, so she was packing up all her stuff in her bedroom. And for some unknown reason, she left her bedroom, went out onto the balcony, and fell over the edge of the balcony to a rather painful death. Her family was convinced she'd been murdered. They didn't know by who, but they were convinced she'd been murdered. Stassen, the other decision I was going to tell you about, is the exact same story. Young Mr. Stassen was, I think, 22, 21 years old when he died. Neither of these people had wills. And he was the kid who didn't fit in. He lived in the country, he moved into the city to go to university, so he's isolated from his family. I teach at the university, so I know Mr. Stassen. He's the kid that on Monday morning when they're all talking about all the fun they had on the weekend, he's not talking to anyone. He's the kid that when they break into group assignments, no one's choosing him. He killed himself one night. He hanged himself without a suicide note. His parents were devastated, as you would be. And what's the common connection between these two families? They contacted all those online providers, Facebook, Google, all those people, and said, we must have access to what our children put online. It's all we have left. And in the Daftari case, they were saying, we're looking for evidence of murder. We want to see what was going through our daughters' minds. And what was the answer from the online providers? Not a chance. They said, unless you've written a will, and in your will you have a separate clause, not the one that says your executor can do anything, a separate clause authorizing your executor or someone else to manage your online accounts, we will not cooperate. Or unless you can show me an agreement you've written during your life where you authorize someone else to manage your accounts. And the reason is because we're an international company and we have to worry about privacy legislation. And privacy legislation goes all the way across the world. And so we're going to monitor these accounts based on the toughest privacy laws in the world, which is California. Now in Canada, because those are 2 American decisions, the Canadian courts say the same thing, except in one case last year, and that's the Henry decision. And you probably heard a lot about Henry, because what happened in the Henry case was there was a woman named Maureen Henry. She lives up in Ottawa, Ontario. Maureen's son Dovey disappeared one day. He was in his 20s. He just disappeared. And Maureen was really worried, and she tried to get everyone involved in helping her find Dovey, and no one seemed too worried about it. But Maureen never gave up. About 2.5 years after Dovey's death, she's reading the internet and she sees a sentence saying a body of a black boy is discovered in Toronto. And she said, I knew in my heart of hearts it was Dovey. And then it's a horrendous story again of her trying to find anyone to help her identify that body. But finally, through dental records, they proved it was Dovey. She contacted all those online providers and said, it's all I have. And the Court of Ontario said, we're going to give you access to those assets. We're going to say that the online providers must provide you that information. But you know what? She has received zero, and she will never receive anything, because the online providers have said, we're international companies. You go down to the United States and you get court orders there, and then we'll talk to you, but not until. It's so important when dealing with sentimental values that you deal with those assets, and you have that clause in your will dealing with digital assets, because otherwise your family is going to have horrible situations after you die. Well, let's see where we go from here. Lack of care registered product designations. I'll do this one really quickly, and then I'll see if Jacqueline wants me to stop and talk about and not do the last two. But what I wanted to talk about here was really one case, and that's the Kalmusky decision, or the Morrison decision out in Alberta. Kalmusky's brand new. It was just decided in Ontario in June. Registered products are wonderful, wonderful things. And they're wonderful, wonderful things because you can have the named beneficiary. So I could say, I leave this asset to my wife, my son, my daughter, and the asset will pass outside of my will. And that means I'm saving probate fees, which is a wonderful thing. But far more importantly, it means money goes to my children's and my family's hands immediately after my death. It's a very quick process. Because you see, the assets in my estate are going to be tied up. And I've had so many estates where I've administered where everything was in the father's name, and the children and the mother come after the father's death and say, Mom needs access to the bank accounts because she needs food, she needs money to buy food and heat and hydro. And you're saying, well, too bad, the bank's not going to allow you to do that. You're going to have to find some other way. Registered products get money into your family's hands when they should be grieving your loss and not worrying about how Mom's going to pay for food. But there was a case called Kalmusky, and it's been followed in Ontario, Manitoba, Saskatchewan, and Alberta, no, not Saskatchewan, British Columbia and Alberta now. And what happened in Kalmusky was there was an elderly man named Henry Kalmusky. Henry Kalmusky had 3 children. One of them was dead, but his boys, Randy and Gary, survived him. Randy lived out west, and Henry Kalmusky didn't see him very often. His other son, Gary, lived with him. He moved in when before his mother had died, before Henry's wife had died, to look after his mother, and he'd stayed there. Mr. Kalmusky had some bank accounts at TD Bank and Bank of Montreal, and he had a RIF. The RIF had $41,000 in it. He went into his various financial institutions and he said, I want to make my son the joint holder of all those bank accounts. So the banks, the TD Bank and Bank of Montreal, added Gary as the joint holder of those bank accounts. He then said, I want to name Gary as the beneficiary of my RIF. So Gary gets named as the beneficiary of the RIF. He then died. In his will, he left 0 to his 2 sons. Everything went to his grandson and his nephew. Nothing went to Gary and Randy. But because Gary was the beneficiary of those was the beneficiary of the RIF and was the joint account holder of those bank accounts, he got about $340,000 outside the will. Randy sued, and he sued and said, I think those bank accounts and that registered account should be returned to Dad's estate and distributed in accordance with Dad's estate. Randy had an agreement with one of the beneficiaries of the estate that they would pay him under the table, apparently. I sort of read questions and it throws me off for a minute. So what happened in that particular case was that, so it went to court, and the court said, joint bank accounts and registered products both are subject to a doctrine of trust. And the courts will presume that regardless of the beneficiary designation, those assets, including your registered accounts, are held in trust for your estate and must be distributed in accordance with that estate. Now, if I leave my assets to my wife, the courts say that doctrine doesn't apply. It only applies if I leave them to someone else, like one child over another child. So in this particular case, the court said, I don't really care who your beneficiary was in your registered product. The starting point is it's being held for your estate and it gets distributed as part of your estate. Unless, Gary, you're the named beneficiary, you can lead evidence that Dad really intended you to have this registered account. Gary was unable to lead that evidence, and as a result, all those assets passed through the estate and Gary got zero. So what's the upshot of this whole thing? Well, when your advisor talks to you and you're going to leave assets, especially registered products, you're going to name a beneficiary of the next generation, it's really, really important that you that you leave evidence as to why. There was a case called Pecor in 2007. And in the Pecor case, the court set out the evidence they'll look at every single time one of these comes to court. And they said, first of all, we must see the notes and records of the financial advisor, and the financial advisor must be a witness at trial, because he's the only person with independent evidence as to intention, as to absence of undue influence or duress. But then we're going to look at anything you left behind saying, this is what my intention was. And that's why it's so important now, since the Kalmusky decision, to leave what your intention was in registered product beneficiary designations. And you know what? And you know, I know I'm babbling now, so I'll stop. But in the Alberta case, Morrison also said it applies to all insurance products, seg funds, life insurance products. The same doctrine applies, that regardless of who your beneficiary is, unless it's your spouse, it'll be deemed in trust for your estate unless you leave evidence as to why it was what your actual intention was. And on that rather bad job of doing that one, I'll pass on. Inappropriate use of probate minimization tools. Now, Jacqueline, do you want me to continue, or do you want to just do 5 deadly sins today and give some time for questions?
You know what, I saw some notes come through for people wanting to continue. So why don't we spend about 5 more minutes just going through the last 2,
Sure.
And then we can do Q&A. Again, if you need to drop off, that's fine. We will send you a link to this recording so that you can finish watching if you do have another meeting at 11 o'clock that you need to jump onto, okay? I just want to make sure everyone gets all the sins if it's possible. Thanks, Keith.
And if there's questions that we don't get to, I will be more than thrilled to answer them in writing and send them back to you. So,
great.
Probate, as I said to you at the very start of my presentation, I want my executor to get probate because I happen to love my executor, and probate protects my executor. So what probate is it's a fee charged by the provincial government to issue what's called a certificate of appointment of estate trustee. So after I die, my executor is going to add up the value of all assets passing through my estate. If they don't pass through my estate, it doesn't have to, but all the assets passing through my estate, and he's going to multiply it by 1.5% loosely, and we'll go through that calculation in a minute. And he's going to write a check to the Minister of Finance of Ontario for that amount. And then he's going to be issued what's called a certificate of estate appointment that allows him to administer my estate. Probate is not mandatory. If you can convince every fund company and every bank and everyone in the whole world, you can avoid probate. However, I want my executor to get probate. And the reason I want my executor to get probate is it protects him in 2 different ways. First way is, if Jack administers my estate and doesn't obtain probate, and then there's later a problem with my will. Someone says it wasn't witnessed properly. Someone says there was undue influence or duress. Someone says I was married after my will, whatever it might be, my executor becomes an executor de son tort. And all that is a fancy way of saying he's duty bound to administer my estate because he started, but he can never, ever be reimbursed for any of those expenses we talked about earlier, and he can never, ever charge a fee. So it's putting him behind the 8 ball because he's going to have all the work, but none of the pleasure. But if I get probate, he's protected. That doesn't occur. And the other thing is it starts the limitation periods. Limitation periods in estate administration start from 2 years from when you knew or ought to have known you had a claim. Well, what does that mean? Well, the courts have said, because when did you know or ought to know you had a claim against my estate? Well, the court said if probate is granted, all limitation periods start from the date of probate. So I want Jack to go to bed one night knowing 2 years has passed, no one is going to sue him again because that 2-year period's passed. If he doesn't get probate, people could argue the limitation period, and people have argued, limitation period continues for 15, 20 years because they didn't know or ought to have known they had a claim. So, although I want him to get probate, I do want him, well, here's the calculation I was telling you about before we go on. Why do people try and avoid probate? Because it's expensive. It's 1.5% of the entire value of your estate over and on top of the first 50,000. The first 50,000 is a freebie in the province of Ontario. But all the assets over the first 50,000, 1.5%. So if you have an estate of $2 million, and that's not hard to do because remember, it's the value of your cottage, your house, whatever else goes through your estate, the entire value of your probate is going to be $29,250. That seems like a lot of money just to protect Jack in case he becomes an executor de son tort. So I want to reduce as much as possible the value of my estate, reduce that $2 million, but I still want to get probate because I still want to protect them. So what are the ways of protecting, of reducing the value of my estate? All of these are the same thing, and it's having assets pass outside of my will, having them pass somewhere outside my will. So the first one is named beneficiaries and RIFs and TFAs, CFSAs, etc. Be careful of that Kalmusky doctrine. Make sure you leave notes and records of what you want it behind, what you intended, because otherwise the asset will be returned to your estate. Named beneficiaries on insurance contracts sure looks like the same doctrine applies. So again, if you're naming your daughter and not your son, be careful and make sure you leave evidence behind of why you chose to do what you want. Jointly owned assets have the same exact doctrine. So jointly owned assets are assets that you own in joint name with your spouse. But the problem is Ontario recognizes 3 different types of joint accounts, and there's tons of litigation of which one it is. I mentioned to you that there was a case called Pecor, and it went to the Supreme Court of Canada. And what happened in Pecor was this. There was a man named Mr. Hughes, and he had 3 daughters, but he only liked one of them, which saves us a lot of time when we're talking about Pecor and Pecor. He had one daughter, I think her name was Cheryl, and she was married to a guy named Michael. Mr. Pecor went into his financial advisor one day, and he said to his financial advisor, I want to add my daughter as a joint owner of my investment account. So now we'll both be listed as joint owners. So that's what they did. He then wrote a will, Mr. Hughes did, and in his will he left half of the estate to Cheryl and half of his estate to his son-in-law Michael. Mr. Hughes then died, and nobody really cared from an estate point of view how Cheryl got her money. Because whether she got it because as a joint account holder, she received that money by right of survivorship, because if you put assets in a joint account, the joint account owner, once you die, receives the money. You don't have the right to leave it anywhere else. Or whether it went through the estate, it went to Michael and Cheryl because they were one household, so who cared? They cared about 5 years later. And they cared because Michael and Cheryl got divorced. And Michael realized, hey, if that asset became Cheryl's by right of that joint account, I can't make a claim against it. Because you see, Section 2 of the Family Law Act says that certain property is exempt from a claim in a divorce. And one of those is inheritances or gifts. And so if she received it through the jointure, it's a gift and I can't claim against it. But if it goes through the will, I get half of it, which is about $450,000. So I get half of it, right? Because I'm a beneficiary. So the court said there's 2 different types of joint accounts. They said there's true joint accounts where you really intend, Cheryl in this case, to receive an ownership interest. And we will assume that that's the law, that's the type of joint account you have if it's between spouses. But if it's between anyone else, the first place is there'll be this presumption that you really intended them to receive it. But what we're first going to apply is a presumption that that person's only holding it in trust and they're holding it for the estate and it must be returned to the estate. So there's these 2 presumptions. And there's tons of case law where families fight about which type it was. Then the courts made it a little more complicated in 2016 because they heard the Sowden decision. And what happened in Sowden was that a man had 5 children. And he put all his assets, which was $950,000, into joint name with his oldest 2 sons. In his will, he left 0 to his children, but left everything to the Jehovah's Witnesses because he was a member of that church. The Watchtower Society, he actually left it to. After he died, The Jehovah's Witnesses said, well, we think it was one of those jointures, which was you were holding it for the estate. And now we get it because we're the beneficiary of the estate. And the oldest two boys said, no, 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 we think this was really intended as a gift. We think it's that other type of joint account. And we get it because we're the beneficiaries. And the other three kids went, what? Dad loved us and we get zero under either one of those. And the court said, oh, I'm sorry, there's three types of joint accounts. And the third one is that the court's going to hold that you formed a trust when you put it in joint name, and you have totally different beneficiaries than in your will. And we're going to say that this was that type of trust. You didn't know you were putting it in trust, but you did. So the law of joint assets is very, very complicated. And when you put assets in joint name, you better leave tons of evidence as to what type of joint account you intended. The other three, I guess I'll sort of skip over unless people are dying to hear about it. Multiple wills are really if you have large scale assets that can pass outside of your will, because the law says you can have as many wills as you want in the province of Ontario or the province of British Columbia. So a lot of business owners say, well, if I put my business in a separate will, my corporation, my executor can deal with those assets without getting probate, because then he can declare himself as a director of the corporation and just deal with it. He doesn't need probate. So multiple wills is a tool largely for business owners. And lastly, to try and keep somewhere on time, make sure you understand the words used in your will. Every word makes a huge difference. And it's important you understand what your words mean. So if your lawyer can't tell you what they mean, have them go read a textbook and come back and tell you what they mean. Maybe I'll just give this example. I have a trust in my will. It's a very, very common clause now to put a clause in your will that says, I expect my trustee to hire my financial advisor, Steve Ferguson, as the financial advisor for this trust. And the reason you do that is because Steve helped me while I was alive, and I want him to continue helping my family after I die. I'm putting the people in place that I think can help Hannah. And so I'm going to name him that. It's really important, if that's the case, that you make sure the right clauses are in place so Steve can do all the solutions he did for you while you were alive. You'll notice the Haslam clause there. Haslam clause is a clause that authorizes my financial advisor, who my trustee hires, to use mutual funds. If that clause is not there, and I've delegated power to my financial advisor, they can't use mutual funds. So it's all these types of clauses that just look like black letter that make a huge difference to your family after you pass away. So with that, and I'm sorry I skirted over the last couple very quickly, that concludes my presentation. Go home and read your will. Make sure it has those clauses. Think about your sentimental value assets. Think about your digital assets. Think about your family. Do you want to pass down your values? Does it reflect how your family is related? Do you want to define words like child, niece and nephew? Do you want to define those in your will? If you have charitable gifts, is that side prey clause in there? And make sure when you look at things about avoiding probate through joint assets or through registered accounts, you've left tons of evidence of what your intention is. Otherwise, you're welcoming litigation into your family. So with that, I'll return it to Jacqueline and Steve and Remy.
Okay, great. Thank you so much, Keith. That was awesome. Definitely a lot of points there. And probably a lot of points that some people wouldn't have considered when just sort of looking at their will. So that actually brings me to the first question that came through on our chat. And that was, how often should we be reviewing our wills? Because obviously there's some major changes that happen, like we have children or we get divorced. Those are very obvious. We need to update the will. But there was a lot of points there, specifically around digital assets and about the definition of children. Those rules change over time, it seems. So how often should people be reviewing their wills?
Yeah, and it's interesting because I think that at the very minimum, you should be updating your will about every 3 years, because the law sort of goes through a cycle of changing every 3 years. But as you point out, also whenever a change in something major in your life occurs, and I'll talk about powers of attorney for just 1 minute. There was a gentleman and a woman who named each other as financial care powers of attorney. And I do a whole presentation on financial powers of attorney. And I don't think it's a great thing when spouses name each other for a whole bunch of reasons, which I go through in that. Mm-hmm. But they named each other as power of attorney, and they never changed the power of attorney, never reviewed it. Well, over the years, they separated and started divorce proceedings. The woman was in a terrible car accident, was unable to manage her financial affairs, so the husband started managing them under a power of attorney. Wow. He was negotiating with himself over his own divorce proceeding because he was representing his wife as power of attorney and himself as himself. The court said he wasn't allowed to do it, but it just shows the change of something happening in your life. You've got to review all those state documents.
Okay.
So every 3 years, but the other thing I will say is the last 4 or 5 years have just been astronomical in the number of changes both legislative and the courts have put in place. So you might want to brush it off right now, regardless of when the last time you looked at it was.
Okay, thank you. Another question that came through is around the digital assets. So obviously this is kind of a newer thing. It sounds like we need to have a specific clause referring to digital assets and giving our beneficiaries permission to access any digital files we have. Is that correct?
That's correct.
Okay. So make sure, obviously, if you have digital files or you think you might, that is something that is included in your will. And just one more that came through, and it was around executors. So that was one of the sins. And you know, there's a lot of people that might not have someone that can be an executor because their children or the people they're close with live out of the country. So, Rami, I know that's a question that you've had a lot in your meetings particularly. Did you want to touch on that for just a second?
Yeah, in some of the slides that Keith had presented, and I wrote this down, like, I love my kids, and I know that one of them is in law school right now, but she's not an accountant. My son's a great contractor, but neither are psychologists.
Mm-hmm.
So I know that a lot of parents would say, give their kids the, ability to be the executor. But what if I don't think I want that type of situation given to my children? What do you recommend, Keith?
I think that if you don't want your children to be your executor, and there's an awful lot of good reasons not to, because you know the number of times it can cause hassle within your family is tremendous, you can always hire a professional executor. And a professional executor is operated by a bank or a trust company. Well, it's operated by a trust company, but all the banks have trust companies. The upside of a professional executor is you're going to get professional assistance, so that your estate is going to be administered quickly, and it's going to be administered to the letter of the law. It is going to, and so that's a big plus. The other big plus is that if there's any liability, if something goes wrong, you have someone with very deep pockets assisting you. The downsides to a professional executor are, one, there's going to be a professional executor fee. Having said that, a professional executor or a lay executor like my son can charge more or less the same fee, and you can negotiate your fee now with your professional executor. And the other downside is they don't know you. So I always think it's a nice thing if you have a professional executor in your estate to also have a clause that they have to confer with one of your children as personal assistant. Things like who gets grandma's asset. It's nice to be able to have the family touch there because, as I've said before, no one who works for that bank has walked a mile on the beach with you, but your children have. And so those personal decisions, it's nice to still have some control of those. Does that answer that one, Remy? Or?
Yeah, no, that was great. Thank you very much, Keith.
No problem.
Okay, and just one more and then we'll wrap it up. So following today's session, what would you suggest that everyone goes and does now that they've watched this? Go review their will?
Have me come and talk about powers of attorney. No, I think you should review your will. And if you, and you know what, a great starting place is Jacqueline, Steve, and Remy have a lot of knowledge, and they have access to people like myself who can also assist. So, you know, a great place to review, and I'm sorry, I shouldn't be saying this because it's giving you more work, but if you have questions about it, talk to your advisor. That's what they're there for, to assist you in that. But do review your will. Make sure you have that digital clause in your will. I can send a copy of it to these guys if you want. It's a drop-dead easy line to put in, but I can show it to them so you can see if you have the clause that the Law Society is recommending right now.
Okay. Well, thank you so much, Keith, again, for joining us. We really appreciate all your insights on this topic today. And thank you to everyone who attended today as well. Really appreciate that. And stay tuned for the link for the recording for anyone who wants to watch any specific parts again. So with that, I will say goodbye, and I hope everyone has a great day, okay? Thanks so much, everyone.